Part 4 of Federalist 80. I have on the screen one of the books that I've recommended to you. It's helpful to understand the Federalist Papers better. Saving the Revolution, it's called. The Federalist Papers and the American Founding, edited by Charles Kessler. I'll start here with paragraph 11. The reasonableness of the agency of the national courts in cases in which the state tribunals cannot be supposed to be impartial speak for itself. No man ought certainly to be a judge in his own cause, or in any cause in respect to which he has the least interest or bias. This principle has no inconsiderable weight in designating the federal courts as the proper tribunal for the determination of controversies between different states and their citizens. And it ought to have the same operation in regard to some cases between the citizens of the same state. Claims to land under grants of different states founded upon adverse pretensions of boundary are of this description. Remember, this is what in Federalist Papers 7 was mentioned, the dispute between Pennsylvania and Connecticut. So it says all these small, something that's not really important can really get out of hand, become big, and then if we don't unite under this new constitution, these disputes will turn out to be a war between the states. The courts of neither of the granting states could be expected to be unbiased. The laws may have even prejudged the question and tied the courts down to decisions in favor of the grants of the state to which they belonged. And even where this had not been done, it would be natural that the judges, as men, should feel a strong predilection to the claims of their own government. So the judges will be taking sides. Depending on which states they come from, they'll take the side of their own state. Having thus laid down and discussed the principles which ought to regulate the constitution of the federal judiciary, we will proceed to test by these principles the particular powers of which, according to the plan of the convention, it is to be composed. It is to comprehend all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizen thereof and foreign states, citizens and subjects. So he reads this from the Constitution itself. This constitutes the entire massive judicial authority of the Union. Let us now review it in detail. It is then to extend, first, to all cases in law and equity. He'll be explaining equity himself here in a little bit. To all cases in law and equity arising under the Constitution and the laws of the United States. This corresponds to the two first clauses of causes which have been enumerated as proper for the jurisdiction of the United States. It has been asked what is meant by cases arising under the Constitution in contradistinction from those arising under the laws of the United States. He's asking what is the difference between these two phrases some cases arising under the Constitution and cases arising under the laws of the United States. The difference has been already explained. We explained it at the beginning of this Federalist. All the restrictions upon the authority of the state legislatures furnish examples of it. They are not, for instance, to emit paper money, but the interdiction results from the Constitution and will have no connection with any law of the United States. There's the difference. The ones that have to do with the U.S. Constitution, like states not being able to emit paper money, that's one. That's not the laws of the United States. That's the law of the Constitution. The ones that he says under the United States, he's talking about federal laws that have been written by the legislature of the United States. Should paper money notwithstanding be emitted, the controversies concerning it would be cases arising upon the Constitution and not upon the laws of the United States in the ordinary signification of the terms. This may serve as a sample of the whole. It has been asked, what need of the word equity? What equitable causes can grow out of the Constitution and laws of the United States? There is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than of legal jurisdiction, as the distinction is known and is established in several of the states. It is the peculiar province, for instance, of a court of equity to relieve against what are called hard bargains. These are contracts in which, though there may have been no direct fraud or deceit sufficient to invalidate them in a court of law, yet there may have been some undue and unconscionable advantage taken of the necessity or misfortunes of one of the parties, which a court of equity would not tolerate. So this is what he means by equity. Yet, in such cases where foreigners were concerned on either side, it would be impossible for federal judicatories to do justice without an equitable as well as a legal jurisdiction. Agreements to convey lands claimed under the grants of different states may afford another example of the necessity of an equitable jurisdiction in the federal courts. This reasoning may not be so palpable in those states where the formal and technical distinction between law and equity is not maintained, as in this state of New York, where it is exemplified by everyday's practice. So I'll stop here because I won't have enough time to finish the whole paper in this video, so I'll postpone it to the next. So again, according to one of the scholars that I've already shown his name to you, J.R. Poe, he says that in what became known as the Courts of Chancery in England, when granting relief under the common law was too strict or too inflexible to satisfy the demand for fairness in individual cases, that's when these courts of chancery came into being. And in the colonial governments, under the colonial governments in the States, or the colonies, I should say, there are not too many courts of chancery. A lot of cases were taken up under just the common law of the time. So there are not too many cases to refer to. But anyways, here he explained what the equity cases would be. Let me read that again since I've got a minute. It is the peculiar province, for instance, of a court of equity to relieve against what are called hard bargains. These are contracts in which, though there may have been no direct fraud or deceit sufficient to invalidate them in a court of law, yet there may have been some undue and unconscionable advantage taken of the necessities or misfortunes of one of the parties which a court of equity would not tolerate. So, under strict reading of the law, one court might not have taken up some of these cases because it says it doesn't break the letter of the law. But under the courts of, in a court of equity, I think, because they want to make things equitable, fair, just, some of these cases will be taken if the spirit of law, spirit of justice, has been is going to be damaged. So I'll stop here and we'll finish Federalist 80 in the next video.